Lawyers have read it. What was your "oh, I'm definitely winning this one" moment? Story 1. I can't really say I'm proud of this one. It's not a happy case, but it was a pretty sure winner. I presented a client once who had gone through a really rough marriage and divorce several years prior. Child owned, a couple of miscarriages. The wife developed postpartum on one, which amplified an existing mental illness. An incredibly sad story. At the time I came into the story, the ex-wife had been in jail for several years, stalking her ex-husband initially, but was still being held because she wasn't competent to stand trial. And I was representing the ex-husband, who just wanted authorization to take over the sale of the house so they could finally finish severing ties. Prior to the trial, the wife's pro se briefs made it seem like she was under the impression they were going to relitigate the divorce, filled with allegations related to the marriage itself. As I said in the previous thread, she already had mental problems, and it was clear she'd picked up some tendencies during her ongoing incarceration. When it actually came to trial, and she was brought in, you could tell she was clearly not well. She was having a conversation with herself while my client was on the stand giving his explanation of the situation. We didn't really have any witnesses to speak of. This was hardly a major matter, so the ex-wife gave her side after that, and that's when the wheels fell off. She basically went on like she had in her briefs, rambling about the divorce itself, claiming my client had committed adultery, and therefore she was entitled to 100% of all the assets, aforementioned stuff, and some general babbling, etc. The judge we had was a nice guy, for which I'm forever grateful. He was patient with her, kind, and reminded her that the initial divorce wasn't the issue, but generally just let her continue to speak her piece for a bit. After a few minutes, he gently shut her down, had the bailiff and guards lead her away, and gave us authorization. Like I said, it's not a happy, "oh Lord, we're so going to win this" case. Just a sad situation, but it was probably my surest winner, other than default judgments. Story 2. The client was a private shuttle bus company that was contracted by the publicly funded regional transit company to pick up elderly and disabled customers, done on a reservation system. The client was sued by a woman alleging that the client didn't pick her up when she called, which was true. She would never make a reservation, instead treated the service like a taxi, and as a result, she had to hitchhike into town and stay in a shelter overnight. She claimed that at the shelter, someone bit a chunk of her arm off and sued the client for $25,000, small claims maximum. I brought an application to dismiss before this went on trial on the basis that the woman's claim was bound to fail. Google the doctrine of remoteness, among other things. At the application, the woman wore short sleeves. Her arms appeared unbitten. Signal 1, this was going my client's way. She argued that the claim wasn't really about the money or the chunk missing from her arm, but instead she just wanted the judge to order that my client pick her up whenever she calls. Signal 2. Admitting your claim is bogus to the judge is not a good strategy. I obviously objected and argued that this was not the case she brought, and that the judge must dismiss it. The judge said to the woman, "I'm inclined to agree with Mr. Dorcas. What would you say in response to his submission?" The woman then lost it on the judge. Signal 3. Called her a racist. That's a bold strategy, Cotton. Let's see if it pays off. Yelled and swore at her, and said her human rights were being violated. The judge was visibly pissed and ordered the woman's case dismissed. I could see the judge gritting her teeth, so I decided to swing for the fences. I asked for an additional order that the woman not be allowed to start any other action against my client without first getting permission from the court. Essentially, I asked for an order that is usually awarded against people who repeatedly and baselessly sued the same defendant. This was the first time the woman sued my client. The judge agreed that such an order would be appropriate and granted it on the spot. I don't think it helped that the woman was continuing to swear at me and the judge throughout this time. Story 3. Not a lawyer, of course, but I lived in a house with a slumlord property manager. Everything looked okay when we moved in, but we noticed a leaking spot in the ceiling. They just came and painted over it, multiple times. We learned after the fact that half the house didn't even get air conditioning and had no air circulation, with windows nailed shut. After a year, my daughter developed asthma, my son had chronic sinus infections, and my husband had headaches and were sick every month. We also began to have issues with bugs no matter what we tried. I sent the kids off to their dads, and my husband and I pulled our crap apart. We found mold on everything, nothing in a visible place because I clean a lot. But once we pulled back the furniture band mattress, it was everywhere. I took pictures and had excellent documentation of our landlord's less than stellar attention. We broke our lease and moved out with their approval versus having them put us in a hotel. We threw away so much crap, all of which was documented. They tried to hit me with a $3,000 bill saying we ripped doors out. Doors I had pictures of being full of mold inside. I had about 100 pictures and about 30 pages of documents. They tried to say we trashed the place. My lawyer sent theirs just a few images and email transcripts, and I had my deposit back a week later. My lawyer said the only reason he took my case was because of all the documentation I provided. Story 4. Not my case, but during my aunt's divorce, custody case. Wasn't really one hearing per se, but over multiple hearings. My aunt wanted full custody of the kids. She initially had custody, but my uncle was allowed to see the kids every other weekend under supervision. Uncle was abusive and nasty even to the kids, and even under supervision. Social services reported his behavior at the hearings. He was rude and arrogant to the judge, wouldn't listen, and even walked out on a few occasions. Even his barrister thought he was a piece of crap. He made it obvious he didn't give a crap about the kids, and he and his mother declared on a few occasions that the kids were a result of incest between their mother and her father. Yeah, he dug his own grave with that one. Judge ruled that normally the father will get some custody, but at least he was making an exception and banning him from coming near the kids until they were 18. Aunt got full custody. Story 5. I'm an Appellate criminal defense attorney, which means I take the case after the defendant has been convicted or sentenced, and I try to convince a court of appeals that he deserves to be released from prison, get a new trial, or get a new sentence. I had one case a few weeks ago that was a total travesty of justice. A black client tried by an all-white jury, not even a single minority in the entire veneer, defended incompetently by a crappy trial attorney who did absolutely nothing for him, who then got convicted on all accounts and received an extremely high sentence for a relatively piddling fraud, higher than Manafort got. I raised 5 different issues on appeal, which is a lot. Typically, I keep it to 1 issue or maybe 2. At the oral argument, the judges on the panel seemed pretty sympathetic during my presentation, though they asked me some tough questions. After I sat down, the government lawyer went up to speak. Before she got a word out, the first thing the judge said was, "This is like a law school exam. There are so many issues here." I had a pretty good feeling I'd win after that one. And indeed, they ended up revising all of his convictions, and my client is now a free man. Story 6. Not me, but my bro managed to force a major bank into the discovery process in a lawsuit, which is totally unheard of due to arbitration laws. The bank's agents had ripped off a wealthy old lady of all her money, and she didn't know anything until her lights were cut off. After fighting and delaying discovery until the very last minute, the bank dumped 200-plus quote-unquote boxes of documents on my brother the Friday before the Monday discovery hearing. He had 72 hours to go through tens of thousands of pages of documents. He rented himself a hotel for the weekend so he'd have no disturbances, had a friend bring a dolly and hand truck the boxes to the room, and got to work. In one of the boxes was an email between 2 VPs at the bank discussing how there would never be a discovery process, so there was no need to destroy the documents, or evidence, and also saying that they weren't worried about the little old lady's lawsuit since the bank had frozen her accounts on some trumped-up fraud allegation, so she wouldn't be able to pay her lawyer and he, my brother, would surely quit. The lady had Alzheimer's at a fairly advanced stage by this time, so the email discussed how she would likely die before her accounts would be unfrozen once the fraud was proven to be false. These chuckleheads openly discussed several illegal acts in emails to each other, and when failed to destroy the paperwork providing they had actually undertaken those acts, which legally they could have destroyed at the time, but they were so arrogant they thought they didn't have to. When my brother entered into that evidence Monday morning, they immediately motioned for a recess and offered to settle for an undisclosed sum. He also won his client $10 million in a separate part of the lawsuit. One agent is currently serving a long sentence in the same federal prison as Bernie Madoff. Sadly, the lady did in fact die before the case was settled, so the money went to her son and to a large charitable trust that then elected my brother as the main trustee. So he gets to disperse the money he won in the settlement, and see a lot of people benefit from his work. Pretty sweet. Story 7. Family law case. I'm just a paralegal, but I accompany the lawyers to court, or did anyway. Woman. Our client is divorced. The father is not paying child support. He is always claiming poor mouth, saying he has no money, etc., always getting extensions to his money owned. He had a business but said it was going terribly and he was owing money left and right, etc. The judges had been sympathetic in the past. However, the guy comes in, he owes $36,000 now for 5 or 6 years back child support, claiming poor mouth once again. Swears to the court he has no money, business isn't going well, shows bank statements. The attorney whips out a Facebook post copy I found, my brightest moment. Guy's young hot fiancé with her new $20,000 ring, 5.5 carats, and her post saying, "Look what my sugar daddy bought me." And he paid cash. Eat your heart out, ladies. The guy looked like his life had ended. We got our full amounts plus interest, and I got a $1,000 bonus. Turns out he was taking business money and never depositing it, so it would show on the books. So the company looked like it was doing terrible when in fact it was doing great. In a later investigation, his business partner sued him and won, and the business went under. For those asking, it was a bar room. And also, I hate family law. It's usually that the scumbag wins or gets away with crap for so long, male or female. Story 8. Worked as a prosecutor and was handling an involuntary commitment hearing. This is hearing when someone is mentally ill, and another, usually a family member, has filed a petition with the court asking for the mentally ill person to be committed for medical treatment when they are a danger to themselves or others. The judge would always make everyone wait for at least 15 minutes before he entered the courtroom. The judge spent at least 5 of those minutes adjusting his toupee. The lady, the one being committed, was wearing only a blanket as she refused to wear clothing. During the 15-minute wait, she was screaming at me, calling me every racial insult she could. The judge walks in, and suddenly her attention turns to the judge's toupee, starts laughing and insulting him, asking why he had roadkill on his head. After 5 minutes of ranting, her attorney turns to me. We are sitting next to each other, not more than 2 feet apart, and asks me to move to have her removed. I said no. She was proving my case for me. After a couple more seconds, I had a change of heart. I felt bad and made a motion to have the lady removed. She kept going on and on. She was taken back to the detention facility by the sheriff's deputy. The lady's husband then testified as to why she was a danger to herself. I don't remember the specifics. There was also a doctor's report submitted. In case anyone asks, this was 20 plus years ago. She was sent to the state mental hospital for 7 to 14 days. I don't remember the exact time, but it is a temporary order, and there has to be a review in a short time to see if the committee should be longer or if the person should be released. She came back to court after having been medicated, and she was a really sweet old lady. She had severe mental problems that required her meds to be adjusted. She was fine, smiling, and in a really good mood when she came back to court. Her husband was really happy to see her again and was relieved she was back to her normal state of health. Story 9. Not a lawyer, just one of the folks gathering documents. The company got an unexpected demand letter claiming we provided a defective piece of equipment and wanted big bucks for the cost of repair and all the downtime it caused. Our in-house lawyer immediately thought something was up. Letters like that are never out of the blue. They're always preceded by phone calls and emails, and he always got looped in on those. So when he called me up to have the document preservation chat, he also wanted me to pull and print all the emails ASAP. There weren't many, maybe 30 mentioning the company. 22 were from the company, and all of them, save 3, were from when they bought the machine over a year before. The last email was the only one I actually printed, and I decided to deliver it myself with one line highlighted. Machine was surprisingly intact for being hit by a motorcycle going that fast. I had never seen our company lawyer smile, nor laugh, but he was doing both as soon as he read it. Story 10. Acted as my own lawyer in small claims court. A cleaning lady I found on Angie's List grabbed the wrong spray bottle to clean a built-in cabinet behind our new couch. The spray bottle had bleach. All of the bleach mist settled and left white spots all over the couch. I thought the whole point of Angie's List was that you were getting insured professionals, but nope. They didn't have insurance. I filed for a small claim because they started to deny everything once I told them my protection plan on the couch didn't cover bleach stains, and I showed them the invoice to replace the upholstery. Their argument suddenly went from, yes, I'll pay the deductible for the protection plan, to, it was like that when I got there. I started to get everything ready, took pictures and videos of all the bleach spots, printed out our text conversations. For a while, I wasn't sure if I was going to win it because it may have boiled down to her word against mine. Then it hit me to look through my old photos and bam! I had taken a picture of my dog a week or two prior sitting on the couch right by the built-in cabinet that clearly showed no bleach stains. So yeah, I won. On another note, if she had just admitted it to me and apologized, I would have given her a break or only asked for half the cost or something. Even still, I couldn't help but feel bad for her, until she told her side of the story in court. I was perfectly calm and nice when I found out they bleached my couch, and she told the judge I was screaming at her. After that, I was all business. Judge ruled in my favor. I told him to subtract the cost of the cleaning services from the invoice, because she gave me back the check I wrote after finding the bleach stains. But technically, they did clean my house and I wanted our business to be fully settled. We stepped out and she wrote me the check. Story 11. Not my lawyer, but during my post-divorce hearing for child placement, my ex-wife spent around 8 hours on the stand tearing me apart, spread over 4 days. She claimed that I was a rapist, that I was abused, that I was an absolutely garbage human being. There were a few moments when I knew that I had won the case. So at the tail end of 8 hours of outright distortions and lies, her attorney asks her what she wants for the placement schedule. She gives an entirely different placement schedule from at the beginning of her testimony that gives me more time. I'm incredulous because if I'm that terrible of a human being, why does she want the kids to have more time? But the coup de grace that she fell right into is when finally at the end of her testimony, my attorney pins her down on the real reason she doesn't want my daughter to have an overnight stay with me. My daughter was 3 and had never once stayed overnight. And after all these claims of abuse, you would expect a doozy, right? Instead, my ex says something to the effect that she's too young and won't understand that when mommy leaves, that mommy is coming back. Basically, object permanence. So the judge asks, so I have a question. When she goes to daycare, does she like being separated from her brother, my son? Oh, no, she doesn't. So does she cry? Yes, she cries. So, he says, is she upset that he's not coming back, or just because she misses her brother? Oh, she knows that he's coming back, says my ex-wife. She just misses him. Right away, I saw what happened. In the span of about 20 minutes, she destroyed her argument that I'm abusive and destroyed her argument that my daughter lacked the object permanence necessary to stay with me. I could have flown. I won my case. Story 12. I own a restaurant bar, and we had a young rookie police officer hovering next door 3 to 4 nights a week towards close, and he was pulling everyone over for failure to make a complete stop. Obviously, most of the people were guilty of a rolling stop. Most people got a warning, but he was trolling for DUIs. One night, we saw him parked across the street, and my friend was leaving, so I went out and stood there as a witness that he came to a full complete stop, in case he got pulled over. The officer saw me standing there, and my friend came to a complete stop. Like a really good complete stop. I walked away after my friend was out of sight. The next day, my friend said that he had got pulled over after I walked away and had blown a .09 DUI. The point of this story is that when I was called as a witness at trial, the officer and my versions of the story were absolutely the opposite. When I was dismissed by the district attorney, I asked if I could make a statement. The district attorney objected, but the judge allowed it. So I said, so if I testify that insert friend's name came to a full and complete stop, and the officer says it was a rolling stop, then one of us is committing perjury. And I'm confident that I am not committing perjury. The courtroom grew a little loud with chatter. We were dismissed. The officer resigned a short while after that. Turns out, as a rookie, he had a ranking officer that was a bad egg, riding shotgun, and made him make the traffic stop regardless of a probable cause. Poor guy getting a tainted reputation from a bad senior officer. Story 13. Worked with lawyers and heard many stories. Here is my favorite one. Now, I will admit I actually felt bad that this guy got away with what he did. I in no way condone what the defendant's actions were and feel he should have been punished. So here is the story. Client was driving intoxicated after a night out of town. He was pulled over by the County A's police department just over the border of County B. Client blew a .20 BAC and had meth and weed on him in addition to his speeding ticket, reckless driving, and no proof of insurance. Client was booked and processed in County A's court. The client retained his lawyer. His lawyer reviewed the case carefully and went to County A DA court. He said he wanted to enter a guilty plea in on the no-proof insurance. The client did have insurance, he just didn't have the proof on him at the time. Naturally, the court accepted the plea and asked what about the other charges. Lawyer said, I would like to go to court on those. DA said, all right. A week later, the lawyer called up the County A clerk and said my client was arrested in County B. Shouldn't that mean he's tried in County B, since it was his jurisdiction? County A agreed that since the client was arrested in County B, he should go to County B court. A court date at County B comes up. The court asks my lawyer to enter his plea. Lawyer states that his client has already pleaded guilty in regards to this case, the no insurance, and that he can't be tried twice under double jeopardy. The court agreed since my client had entered a guilty plea already, that it wasn't legal to try him again, and the client's punishment was provide proof that he had insurance at the time of the incident, pay a $40 fine. Story 14. I had a client who had a pretty severe slip and fall in a pharmacy. In my state, we are not allowed to see surveillance of the subject until after the deposition or other similar testimony is taken. The rule is in place to protect defendants so we don't coach the client based on what we see in the video. Anyway, we take the deposition, then they send the video. Not 30 minutes later, I get a call from opposing counsel wanting to settle. The video revealed that my client had fallen, passed out, and peed herself. She was very elderly and very hurt. The manager of the store had an employee put signs out showing wet floors and mopping up around the lady, all while she was unconscious, all before calling 911. Settled that one for the policy limits right there. Story 15. I was defending a company being sued for kicking a customer out for being drunk. He showed up to trial, small claims, wasted at 10 a.m. The judges in small claims are lenient on the process. They like to adjudicate on merits. So we started. He's the plaintiff, so he goes first. Can barely stand during his opening statement. Knocks over his shopping bag full of evidence. Just awful. The court put a stop to it and ruled in my client's favor. The only words I spoke were putting my name on the record.